Annenberg Media.
In the year 2000, the federal government passed a law that requires states to strengthen their DUI laws or lose money for highway construction.
We're telling you what to do whether you like it or not. And I don't know that you get to come in and force a decision on us when we enjoy certain rights under the Constitution.
Hello, I'm Renee Poussaint. Back in 1787, the notion of a strong national government did not sit well with many of our founding fathers. After all, hadn't we fought to be free of a king? So they sought to balance the powers between a centralized federal government and the 13 sovereign states. It caused intense debate. When the dust settled, the Constitution they created delegated only a few powers to the federal government, reserving all others, by implication, for the states. They called the form of the new government federalism. Because the constitutional delegation of powers was written to be flexible, the lines between federal and state authority are often blurry, adapting to changing circumstances through the centuries. As a result, American federalism has evolved into complex relationships. In some cases, especially in areas where a problem is not contained by state borders, the national government imposes its will on the states. Sometimes the states comply willingly, and sometimes they raise strong objections. The Endangered Species Act grants the federal government the power to protect certain animals, and no species has gotten more attention than the gray wolves who were reintroduced into Yellowstone National Park in central Idaho after a 60-year absence. In March 1995, the U.S. Fish and Wildlife Service, along with the Park Service and environmental groups, brought a number of gray wolves into public lands in central Idaho to reestablish the species in their ancestral ranges. Ironically, it was the federal government which helped eliminate wolves from the area only 6 decades earlier.
Well, the federal government has a legal obligation to restore endangered species, and the wolf was one of the first species that was listed in the Endangered Species Act when it was passed in 1973. Looking at suitable habitat for them around the country, the biologists were able to determine that this area was one of the best places to restore them. Because there's less human conflict here, there's less people, mostly public lands that wolves are on, and their natural prey is still in abundance here.
The state of Idaho did not share in the enthusiasm over this homecoming. It raised vehement objections on the grounds that the people who lived in Idaho should have the right to decide what animals lived in their state. Ranchers and farmers who make their living in and around those lands argue that wolves pose a direct threat to their livelihood. And though there had never been a documented case of a wild wolf attacking humans in the United States, some legislators even worried that wolves were a threat to people.
I have friends in Alaska, when they send their children to school, they walk them to the bus and they go armed. Do I have to live like that in Idaho? Shouldn't have to. But just so somebody from out of state or back east, or somebody that sits in an office all week and thinks wolves are cute and cuddly and how pretty. No, this is Idaho. And they don't have any right to visit those kinds of things onto my state.
Despite these objections, the wolves were released. And now the federal government expected the state to assume responsibility for managing them. State authorities, however, refused to accommodate what they saw as a federal abuse of power. They passed legislation demanding that the wolves be removed. Some threatened that they would have the wolves removed by any means necessary.
The federal agency, of course, they were the messengers, and so most of our people initially wanted to shoot the messengers, and there were some threats to do that physically, as you can imagine, when the wolves finally hit the earth and were turned loose, and then particularly when those wolves began to kill little calves and horse foals. There was, of course, outrage in the local communities, and there was a great deal of anger and animosity towards the federal administrators.
One such federal administrator is Carter Niemeyer, wolf recovery coordinator for the Fish and Wildlife Service based in Idaho.
When there was a concern about wolves eating deer and elk and livestock, the state of Idaho didn't see a whole lot of things that looked really positive for their local residents. The problem you get into again when you deal with these type of issues is there's a large amount of federal land in Idaho that belong to all the citizens of the United States. And so it's difficult to explain to local residents who become very upset when they think someone in New York City is making decisions for them. But in reality, the issue is when there's public lands involved that all the citizens in the United States are going to have a say in this whole thing.
The federal government had Idaho over a barrel. As long as wolves remained on the endangered species list, federal restrictions on how to deal with these animals had to be followed. This meant that local ranchers had very little recourse in protecting their livestock from the predators. The wolves would not be removed from the list even if the population reached the recovery goal until the state developed its own wolf management plan, one that would not only keep the wolves away from livestock, but would ensure that the wolf population remained at healthy levels. State officials began to realize that their hands were tied and they would have to deal with these new residents.
Under the Endangered Species Act, there is no choice. You must work with the law, you must work within the law, and whenever there is a clash, a direct clash, state and local interest will lose. It's that fundamental. So there really was no choice. And eventually people were educated, they learned. You know, we all learned about biology as well as about government, and that brought us to where we are today in Idaho.
Who's going to be out there to know when we drop below that level? Because when we drop below that level, if the Forest Service gods decide, or the Fish and Wildlife gods decide we've dropped, we go back on the list. It is a never-ending problem. And the only way it will be resolved is to remove the wolves. We got along with it. It was done before. It was done for a reason. People and wolves will not coexist. So I think we'll head down that road again when people wake up. And if the people back east don't like it, quite frankly, they can go suck eggs.
There will still be ongoing challenges by rural residents who aren't going to accept that wolves are here. But more and more people who live in Idaho have come to the realization that we tried to prevent wolves from being reintroduced in this state, but they are here now. And I think a lot of people are recognizing that we're going to have to live with this decision now. We can't go back. We probably won't go back. So now the issue is, as wolf managers, how are we going to make this work with the best interest of all of the different people involved and try to find some kind of a way that we can all live together with wolves, because we're going to have to.
There are times when the federal government expands into areas that are traditionally the domain of the states by offering substantial financial help. Sometimes the funds are offered to the states as a carrot. Do what Washington asks, and we will reward you for your cooperation. And sometimes the stick approach is used. That is, adopt a national policy or significant federal funding will be held back. Nearly 40% of the deaths on America's highways are caused by drunk drivers. It's a national crisis. Traditionally, the states have had sole authority to regulate all matters related to automobile safety within their borders, including the setting of standards for drinking and driving. In the 1980s, advocates for legislation to control drunk driving brought pressure to bear on federal lawmakers to create national standards. The U.S. Congress responded by passing a law that offered states a large cash incentive for setting a standard to define when a driver could be declared legally drunk and subject to criminal prosecution. How do you set a standard? You use a machine to measure the blood alcohol level of drivers at the time they are stopped on the road. In the state of South Carolina, no such standard existed. Instead, those pulled over for drunk driving could go to court and force the prosecution to prove that their ability was impaired, regardless of how much alcohol they had consumed. A group of senators in the South Carolina legislature objected to the federal government's call for a blood alcohol standard.
That we're now going to surrender the question of a judge and jury to a machine.
Opponents succeeded in keeping the legislation buried for 10 years, making South Carolina one of only 2 states refusing to adopt a standard.
Why does South Carolina not have this legislation? I don't understand. We've got a handful of senators who have a vested interest in not passing this law.
Finally, in 2000, the standards legislation made it to the floor of the Senate. Safe driving advocates like Mothers Against Drunk Driving held press conferences on the steps of the state capitol and patrolled legislative committee rooms where a battle raged between those who favored the machine standard and holdouts who wanted to keep the trial by jury status quo.
This really is one of the worst proposed laws I've ever seen.
I'm concerned about drunk drivers on this road, but I'm also an attorney, and you're an attorney, and we have an ethical obligation.
I am a representative for the state of South Carolina as I sit at this desk, not an attorney. And that's the way I have to look at it, Mr. Lucas.
Mr. McGee.
Not in my profession, but as a representative of the state of South Carolina.
Represent one at a time in our district.
Finally, a compromise was reached. A .10 blood alcohol level was adopted. But a defendant could challenge the test results, have the right to a jury trial, and require the state to show that the machine used for testing was accurate.
My parents were killed by a drunk driver in 1992 while crossing the street. He was at a .09. The legal limit in the state in which they were killed was .10.
Safe driving advocates were not satisfied. States were adopting laws that set different drunk driving standards. They wanted one national standard, .08. Federal lawmakers, feeling the need to get tough, responded by attaching a sanction to the 2000 Transportation Appropriations Bill, requiring states to pass a .08 drunk driving standard or risk losing a portion of their highway trust fund monies.
Incentives weren't working, so we had to put a sanction in place. And we put in place in this legislation regulations that required the states to pass .08. And if they didn't, after several years, we would begin taking away their highway funds. And those of us who worked hard to pass .08 had to explain to our colleagues who disagreed with us that this is about lives. This is about saving lives. And if we have an opportunity to save lives, then we have an obligation to pass legislation that would preempt states' rights.
Adopting a .10 drunk driving standard had been no easy matter in South Carolina when incentive monies were attached. Now, failing to adopt a .08 standard could mean losing federal highway funds. State Senator Brad Hutto felt that Washington's coercive approach was high-handed.
If you want to give people an incentive to alter their policy, I don't necessarily see anything wrong with the incentive approach. But the penalty approach strikes me as just heavy-handed big brother. We're telling you what to do whether you like it or not. Because in many instances, when you're from a small state, a rural state, a poorer state, that money means a lot. And I think they know if they penalize you enough, you'll almost have to take it. You'll just have to take it whether you agree with it or not.
Other South Carolina legislators, like State Senator John Hawkins, had a different viewpoint.
I would have been for .08 even if the federal government had not have mandated it. Just because the federal government has mandated it doesn't make me less for it because I'm a South Carolinian.
In the year 2000, the federal government passed a law that requires states to strengthen their DUI laws.
In 2002, Senator Hawkins introduced a bill that would put South Carolina in compliance with the .08 standard.
If we in South Carolina fail to act, then we will lose $6.5 million in the year 2004.
I introduced it the first day of session, and we held a big press conference, and it was publicized widely in South Carolina news that this bill had been introduced. It basically takes us from .10 impairment level down to .08, meaning that if you're caught behind the wheel with .08 alcohol in your system, then you are considered to be legally impaired and you're guilty of driving under the influence, period. I introduced it the first day of session. It was referred to the Judiciary Committee in the Senate. Unfortunately, it has sat there all year long until about a month ago. The chairman brought it up on the agenda. It was referred to a subcommittee, and we are waiting for that subcommittee to hold a hearing.
Whether people in other states or on the national level agree with decisions we make, the prerogative is ours to make those decisions. And I don't know that you get to come in and force a decision on us when we enjoy certain rights under the Constitution.
Will South Carolina accept the .08 standard imposed by the federal government in order to gain the badly needed millions for interstate highways? Perhaps. But when the issue gets tangled up in a debate between state and federal powers, all bets are off. The transfer of national versus state powers can shift in both directions, and sometimes the federal authority over a particular policy area is reduced and power shifts to the states. This is called devolution. When this happens, it means that whatever the nature of the authority may be, there will no longer be a unified federal standard for administering it. Citizens of each individual state will have a different experience, a reality that has become evident in the gradual devolution of the nation's welfare programs. For most of America's early history, caring for the poor was left to local communities and charities. But in the 1930s, the country was caught in the grip of the Great Depression and facing poverty on such a scale that the federal government stepped in to help.
I pledge myself to a new deal for the American people.
As a solution, President Franklin Roosevelt proposed a New Deal for America that brought sweeping federal social welfare programs. 50 years later, many Americans had lost faith in the growing federal government's ability to solve the problems of the poor.
Tax rates after 50 years of taking power away from the hands of the people in their states and local communities, we have started returning power and resources to them.
When Ronald Reagan became president in 1980, as part of his overall mission to shrink big government, he tried to shift authority for social welfare programs to the states. He did not succeed at the time, but did set the stage for what was to come.
In the 1990s, there was a lot of concern that welfare just wasn't working. The number of single-parent families was growing, poverty was growing, the welfare caseloads were growing, even when the economy was good. And there was a sense that we were not taking an effective approach to reducing poverty.
In 1996, President William Clinton signed a welfare reform bill that transferred much of the responsibility for welfare from the federal government to the states.
Today we are ending welfare as we know it.
Under the new law, the federal government gives the states block grants of money to help the poor. How the states move people off welfare and into work is up to them.
The difference is that states are now in charge of how they want to set their welfare policies. They determine who they serve and what they're going to get. They had some flexibility before. Now, many more decisions are up to them.
At the time, I make that a small T for teacher's aid.
Some states like Michigan offer supports to those moving from welfare to work, helping them to become independent.
So identifying anytime you can tie in where you used Excel or Microsoft Word or filing into the job duty.
The service system strategy really looks at what do we need to do with that family to help move them into the workforce and help strengthen the family.
It felt big. It felt big. It felt like I'd beat it. I had beat the poverty level.
Melissa Gugamos is one of Michigan's success stories. She made it from welfare to full-time work as a teacher's assistant. But the journey from where she started, a single mother disabled with rheumatoid arthritis, to independence was far from easy.
I was an evicted, divorced mother with a 7-year-old and a 1.5-year-old with steel rods in my feet. That was not easy.
Before welfare reform, Melissa received welfare benefits, but without much incentive to work. The new law meant she would have to work at least part-time in order to keep her children's health insurance.
Anybody has that fear where you're going to lose your kids' insurance. I think that makes you stay in compliance with the system.
But even that threat would not have made full-time work possible, she says, without a strong state program and lots of support. To make the transition from welfare to work, Melissa received child care, job training, food stamp assistance, and health insurance for her children.
Not only do we try and help them access critical supports like food stamps and Medicaid, we also think about what does it take to go to work. As we look at the investments to move people to work, things like transportation and child care have been critical.
But it paid off. You know, it really paid off. Today, I'm full-time. I have full benefits. For myself, it made me strive more. I can enhance my life. I can do something better with my life. I've been very fortunate and blessed.
Where Michigan provides major supports for women moving from welfare to work, other states provide only minimal assistance, especially poor states like Mississippi.
The Mississippi legislature was responding to this kind of groundswell of, you know, we're tired of poor people, and we think people ought to be out and taking care of themselves. The emphasis was off welfare, move people off welfare. And the federal language that said from welfare to work got lost in that.
Oleta Fitzgerald heads the Children's Defense Fund in Mississippi. She says many of those who dropped off welfare in her state simply couldn't find jobs. Others found only minimum wage jobs, and without basic support such as childcare, she says, many won't be able to stay employed.
You have some money in your pocket? No. How you gonna pay for your lunch?
2 months ago, Regina Wilcox was working full-time and shuttling her daughter from school to daycare while studying for a higher-paying job as a medical assistant. Last month, she got her school certificate but lost her babysitter and had to quit her job. Under the state program, she doesn't qualify for child care assistance.
And they're telling me I can't apply for it because I still have to be a student or working. I'm falling into some dead ends, not knowing what I'm going to do.
Regina moved in with her mother to make ends meet while she looks for a new job.
Right now, my mom is working 2 jobs to make sure the bills get paid, and we're okay. But at the same time, I don't want to put all my burdens off on my mom because she did her part, and it's time for me to do my part for my daughter. But I've been working ever since I was 17, and I'm not afraid to work.
Good morning. I was calling about the educating in the paper.
According to the Children's Defense Fund, Mississippi provides child care for less than a third of the children who qualify.
Basically, it boils down to 2 kinds of efforts. People who are trying to get people off welfare and into jobs, and people who are trying to get people off welfare. Unfortunately for us, we're falling into the latter category.
While welfare reform appears to be working, the perspective on just how well it's working would seem to vary widely from state to state.
Devolution means we're going to see more diversity of approaches to problems from one state to the next. And this could be a problem over time. The things that hold us together as a country demand a certain amount of uniformity. If we let every state go its own direction, we may get creativity, but we also lose some of our sense of what it means to be a nation.
Is it really necessary to have 50 separate states? After all, aren't we all Americans, no matter which state we live in? Is it possible that although federalism made sense at the time of the Republic's founding, it no longer serves a useful purpose? In fact, state governments and the local governments they create are responsible for providing most basic services Americans depend on: education, public health, criminal justice, water, trash disposal, clean streets, fire and police departments, most of the essentials in our daily lives. Would a central government with all the powers necessary to provide these services be as effective? Could it be as sensitive to individual differences? Would you call the White House to repair a pothole? On the other hand, can we trust the states to provide for national security? Can the states adequately protect Americans from problems like air and water pollution that flow across state borders? So where should we draw the line? What should be left to the states, and what should be done by the national government? Americans have debated this question for more than 2 centuries, with no end in sight. For Democracy in America, I'm Renee Poussaint.
Annenberg Media. For information about this and other Annenberg Media programs, call 1-800-LEARNER and visit us at www.learner.org.